And so today is the date scheduled in this matter for the pretrial as well as plaintiff's motion for summary disposition. And you all spoke outside, and my notes from January 9th show that Mr. Murdoch is claiming the account is not his. And then, so my question is this, Mr. Murdoch, did you file the ID theft affidavit for plaintiff to investigate the fraudulent account per their policy?
No, Your Honor, I did not.
Why did you not do that, sir?
There was nothing in state code or law compelling me to do their work for them, Your Honor.
Sir, I ordered that you were to submit to that.
Your Honor,
Your allegation is that it is not your account. So I ordered that you were to submit the ID theft affidavit to the plaintiff as required for plaintiff to investigate fraudulent account per their policy.
Your Honor, Michigan Court Rule 2.310 says that a court order must be written, and if I object, there would have to be a written order from the plaintiff requesting that and formally written requested by a judge. You didn't put it to me as an order, Your Honor.
Oh, I sure did order it when we were on the record, sir. I also ordered that you were to provide, that the plaintiff was to provide you proof of where the payments came from for the account. Did you do that, counsel?
Judge, I can answer that. I'm gonna go a little closer, son.
Yes, that's fine. Dave, who's? Just one
Can I
moment,
go for it?
just one moment, please. Can you, please turn the lights on a little bit, more so? Thank you. Okay, so did that occur, counsel?
Thank you, Judge. Can I go to court? From the last pretrial, I did make an inquiry to the plaintiff. They went back to the original creditor, who was Stringy Bank. Now, the record of Stringy showed that that was a debit card payment. But because of the age, and let me tell you about that, it's not that banks do things willy-nilly. They have to do things as required by federal law. Just in 15 seconds, I can show you that the financial services industry is the most heavily regulated federal industry in the country. There is actually a statute in federal code that says banks are required to maintain banking records only for about 2 years. Now, I'm not saying that as a whiner or an apologist, but I can tell you as an officer of the court after all these years, for aged accounts, you know, again, the actual record get expunged. But I can also tell you, Judge, that from my notes from the January hearing, that defendant was supposed to mail me copies of his banking statements at that time. I don't have them. Again, he said, well, there's not an order from the court. And I'm only reading over from the pretrial notes from the last hearing that was in January. So if I can't get any cooperation from the defendant, really, I have to fall back on my pleadings, you know, and ask for judgment based on the facts that I put not only in the as attachments to the plaintiff's motion with exhibits, but also the plaintiff's reply brief to defense answer, because I'm not getting any cooperation from the defendant.
Okay.
Heard on the record.
My question is this, counsel, did you provide defendant proof of where the payments came from for the account?
No, because again, they don't have the routing number and the account number from that time. They merely show on their statement, yeah, we received your payment on that time. I mean, I can't put any simpler, but that's what they told me.
Okay, so did you send that over to Mr. Murdoch?
Well, if you're saying if I sent a letter or an email from Mr. Murdoch saying on the record, saying in an email, I just told you now, the answer would be no.
Okay, so neither one of you complied with this court's order as to what you should have been doing over the last 3.5 months. And then, Mr. Murdoch, you're to provide all attachments
But
to,
so, Judge, I did send again in January 15th, another fraud affidavit, you know, so my records were twice I sent it to the gentleman and twice I hadn't gotten anything back.
Okay, so did you, sir, Mr. Murdoch, did you receive another ID fraud affidavit?
No, Your Honor.
Okay, please stand up when you're addressing the court. No, not at all.
No, Your Honor, not at all.
Right here.
Where did you send it to, counsel?
I have a copy of it.
And which court rule were you referencing, Mr. Murdoch? 2.310?
The court rule for the
Right, the written orders. 2.310 you said, or 2.301?
NCR 2.310.
2.310.
Yes, Your Honor.
So anyways, I have a copy of what I originally sent, well, sorry, this original thing. Oh, yeah, it was actually in my name. November 2025, sent to Mr. Murdoch at 560 Maple Street, Apartment 1 in Wyandotte. I have a copy, I'll be delighted to have around the record. I'm sure I sent it to him twice, one by mail, one in November, and then again in January 2026, again to the same place. I don't know what to tell you, Judge, when I do it twice.
You still reside there?
The record.
Your Honor, my main issue here is not the identity theft affidavit, it's the fact that this payment, this case was filed in 2024. They've still yet to be able to prove that this payment originated with my bank account. I provided this court with my bank statements, clearly showing that there was nothing out from the date that they claimed. I believe that's pretty sufficient proof.
Well,
I thought that you were claiming that the account was not yours.
Originally, the whole point of this whole lawsuit, my statement that I made was that this $50 payment never came from me. This $50 payment that reset the statute of limitations 30 days after this account was acquired by LV&V funding, this payment did not originate from me. That's why I provided bank statements and went as far into that as I did.
Okay, and so your response to that, counsel?
I'm sorry, I was listening and then you quickly said something.
Right.
Please.
So your response to the defendant's claim that the $50 payment did not come out of his account, and that that's your burden to prove that it did in fact come out of his account, whereby resetting the time for the statute, the judgment.
Thank you. I understand the question, and I'm looking at my notes from the record from January. And Penn apparently stated on the record, he sent the court some bank statements to prove that payment didn't come out of his account, but that he did not send that to my office. And that he said,
Okay, let me
well,
pause.
no.
Just a
I don't know
moment.
what that-
Did you end up sending that over to Mr. Rusin?
I did not. Once
You're required to send it, sir. Whatever you're sending to the court, you have to send to the to the opposing party.
From my understanding of what I read, when that regards financial documents, that is not the case with personal account numbers and details on that.
Sir, you can redact certain things so that you don't have to worry about some identity theft. But how do you expect any communication is going to occur with the opposing party if they do not have the documents that you're relying on?
Your Honor, if I may, respectfully, it is not my job to provide them with evidence for their case.
It is your requirement, sir, when you are submitting something to the court, to submit it to the other party. That's the requirement. Otherwise, it's ex parte communication. So that is why I asked you, again, why you didn't send it. So now what you're going to do is you're going to go have a seat in the lobby, and the two of you are going to go over, you're going to show him the bank statements, so Mr. Rusin can review those, because that's what you're relying on.
Today,
I'm sorry?
bring my bank statement.
Sir, that's what you're relying on as your evidence. Why would it,
Ma'am.
why? Yes, they're filed in our electronic file, sir. There are in our electronic file, our paperless file system. So you should have those documents with you so that you can go over those with Mr. Rusin.
I can pull them up electronically on my phone.
Perfect.
Okay,
So I'm going to have the two of you do that.
that's great. So that's wonderful, Judge. I mean, I'm sorry if I saw that, I don't mean to live, but that'd be great. And, I mean, I don't want to be lurking over the gentleman's shoulder. If he wants to go out in the lobby, hold that up or sit, fine, then bring me over and we can go out and review.
Right, we're going to have you do that in the lobby, okay? Because I will say that, I don't know if this has occurred in any sort of issue that you've had before. but I will take judicial notice that there are individuals that for some reason fraudulently obtain an individual's credit card information, make charges, and then even pay on those charges.
Sure.
And I will say that because, and I'll disclose that just because this has just recently happened to my husband on 2 separate credit cards. So Mr. Murdoch is claiming that it was not his payment that was made that would then renew the judgment or the statute of limitations. So I need for you to both go through that to see what's occurred.
And I understand you perfectly, Judge, and just so Mr. Murdoch understands, if the plaintiff's records from the original card show that there was a debit card payment made, that should show up on the gentleman's bank statements. You mentioned checks. I don't know anything about checks.
That's a bank statement.
If
He has a
you
bank
have statements, I can review statements.
It will absolutely show if there was a debit on that date, it's going to show on his bank statement.
That's right.
Correct. All right, so I'm gonna have you guys go out into the lobby and we will review that. You're welcome. So I had the 2 of you go out into the lobby so that you could review some information that Mr. Murdoch had. And
Yes, so the answer is yes. So I did have the opportunity, while the case has been recessed, to review Mr. Murdoch's bank statements from the period in question that was the turning point back in this case as the date of the last payment for the credit card that is now on your docket. I am satisfied. I am satisfied as the plaintiff's attorney to stipulate to dismiss this case with prejudice. I have reviewed the dismissal document with Mr. Murdoch. I have signed it. Mr. Murdoch has countersigned it, and I am prepared to present that document to you, Judge.
okay, Dave, if you can grab that, please.
Thank you.
Mr. Russo.
Oh, thank you.
Okay, thank you. Okay, and so the court will sign this. And we will have it entered.
Judge, should I just present it to the clerk's office, or should I file it when I get back to my office?
Alicia, what are we going to do? Are we doing it? Are we just gonna,
My file.
My fault, right, that's right, guys.
right, so are we doing that since I signed the judgment right here, or? We should probably do that, and then you'll each get a copy of it, just
Yes.
because this is the original, so this way we'll upload it and then you all get a copy of it.
Okay, so the courts now have the copy, it's gonna
Yes.
be scanned appropriately by the clerk's office, put on an file, and then we can retrieve a copy of it next year or 2 or whatever.
Correct,
That's correct, Judge? Thank you.
yes, all right, thank you very much, both of you. All right.
That's why the senior partner comes down to these hearings and not the appearance count.
All right, have a good day. I like your printing.
Hope it works out.
Thank you. See you later.
All right, thank you, Judge.
All right, have a good day.
You too, Don.
You're welcome. Thank you. Off the record. All right, and so counsel, you and Mr. Cass were able to speak in the breakout room, is that correct?
Me and Mr.
Sorry, Mr. Keaton.
Keaton, yes. We
Yeah.
did speak, Your Honor, we did not enter into any agreement. I did have one alternate thing that I can offer to Mr. Keaton if maybe I could speak with him.
Oh, you want to speak to him again in a breakout room?
Yeah, I just.
Can I
thought of
ask a
something.
question, Your Honor?
What's that, sir?
So I was told by a lawyer friend that she couldn't represent me because she works out of Detroit. But long story short, the situation with Green Tree started because back in January, a coworker stole a money order when I paid my rent, but she gave me receipts for it. So when I came to pay my rent in February and they were still trying to get me to pay for January, I wasn't going to let them just do that to me. And the person who replaced the regional manager, I made the regional manager quit because they kept harassing me. They were texting me, Your Honor, texting me, leaving me voicemails saying, hey, let's just work something out to keep this out of court. I made this woman quit 2 weeks ago, and literally a week ago, her replacement called me leaving voicemails, miss, but it was 6:10. The office closes at 6. They are doing a lot of fraud. It's no reason I should owe all the money I have, but that's
Okay,
here nor there.
okay, sir,
my
just one
I'm
moment,
sorry, my
please.
apologies.
That's
My
okay.
question was, I will be moving
So-
into my apartment if I could next month on the 20th. If I was told that it's a possibility that if you wanted, I could get 30 days. If I could get that, I will be out of here. I have no damages other than the damages that was already done that they have.
Okay, okay, sir, just one moment. Mr. Katz, I will put you back in the breakout room to speak to Mr. Keaton regarding these issues, and then we will call this back on the record.
Okay, and Your Honor, I think we might have a consent because he just agreed to something that I was going to offer to him, but I'll talk to him.
About
and
30 days?
clarify. Yeah, I was gonna give him until the 20th and convert this to termination.
Okay,
I would definitely, if that's the case, I'll take that. Thank you.
okay, there we go.
The only
Thank you very
thing
kindly.
I would request from both parties, my client and Mr. Keaton, they should not be communicating either one of them because this has been an issue.
That's very, thank you very kindly, sir. That's not a problem at all.
I'm not talking about just my client, Mr. Keaton.
Oh, I heard you the way I heard you. Trust me.
Okay, all right, just making sure.
So Mr. Keaton, you're going to move out by May 20th, correct?
Yes, ma'am. I will be gone the day of the 20th. The only reason I'm still here is because I'm putting things in the U-Haul. I will be gone. I will be dropping my keys off or leaving them here if that's what they would like me to do in the apartment.
Okay. All right.
Thank you very much. I appreciate everything. Could I leave now?
No, not yet.
Okay.
Sir, you have heard the terms of this judgment, correct?
Yes, ma'am. Yes, Your Honor.
And you understand that Mr. Katz represents the interests of your landlord and not your interests, correct?
Yes, Your Honor.
All right. You also understand, sir, the rights that you've received in your packet of information. Do you understand that?
Yes, Your Honor.
Do you have any questions regarding that?
Not at all.
All right. You also understand, sir, your rights under the court rule, correct?
Yes, Your Honor.
All right. Do you have any questions regarding that?
No, Your Honor.
All right. You also understand that that neither you nor the property management company, Braintree's Apartments, are to have any contact and conversation with each other, correct? Do you understand? You're muted, sir.
My apologies. My face hit the phone. Yes, Your Honor. I understand. No contact of any kind.
I'm going to actually indicate no verbal communication. That way, counsel, if there's an issue with the apartment, then it can be via email or something.
I agree. That works.
Your Honor, for the record, with that being said, should I leave my key in the apartment that day?
If you could email them confirmation that you've moved out and the keys are left in the apartment, that would be perfect.
Okay, perfect.
All right. The court does find that the waiver of rights is valid. The terms of the judgment are reasonable. The court finds by consent that plaintiff is entitled to recover possession of the property. The amount now due and owing for unpaid rent and other costs is 0, and that defendant is going to relocate by May 20th. Sir, do you have any objection to the court indicating via Zoom on your signature line of the judgment?
Not at all, Your Honor.
All right. The court has signed this judgment, and you all will receive a copy of this later today.
Thank you very much.
Thank
You're
you, Your Honor.
welcome. Good luck to you. Thank you.
Thank you
Have a
kindly.
good day.
Have a great. Yep, you too.
And Your Honor, I think that was it
Bye-bye.
for me now.
I believe
Just a good
so.
weekend. Have a good weekend.
You as well. Bye-bye.